So, Steve, you mentioned the several states and how that might apply. Why might Jane Doe be suing in New York and not any of these other states? So, one question I wanted to ask first is, what do you both make of this entire lawsuit? And I'll start with you, Andrea.
Well, it is obviously trying to pack a punch, but my initial impressions of it are that it is likely to be severely flawed in some pretty critical ways, which I'm sure we're going to get into some of the details about that as we go on in the conversation. Some of the things that I've noticed, quite frankly, it does not seem particularly well written to me, although I will say that in some respects it comes across as very craftily written. There are certain points where things are framed in passive terms, which is a little bit of a tricky way to say that these things happened, allegedly to Jane Doe, but without going on record attributing in a provable way that Brian Warner, Interscope, Nothing Records, etc., are the ones who are responsible for doing this. There's also a lot of interweaving of what, from my perspective, is quite clearly constitutionally protected First Amendment activity with these allegations of, criminal conduct and grooming and stuff like that. And then, of course, the whole issue of this being in New York in the first place, the jurisdictional hook to New York seems to me to be quite minimal beyond the specific acts that she's alleging took place in New York. So my general impression is that this is likely going to be vulnerable to a pretty aggressive attack by Howard King. But of course, the downside is that a lot of these issues may be quite complicated from a legal standpoint. And so it's putting him once again in a position of having to divide his attention, divide his efforts, have his paralegals running down legal research into questions on this that then takes up their time and keeps them from being able to address, for example, the pending anti-SLAPP and the ongoing discovery and things like that in the other cases.
Yeah, now I will say when Andrea says there's complicated legal issues, there's complicated legal issues, and I don't know the answers to some of those. And I'm sure we'll touch on those as we get into the other questions that are more specific. This lawsuit, of course, has, I think, maybe the nastiest allegations, in large part because of the alleged age involved. And it also is going to be quite dynamic because Manson supporters are saying, hey, this person has gone into the media with accounts that don't match up to this lawsuit. So the nature of the allegations makes it bad. I feel like there's a lot of the stuff that's in the lawsuit is there to try and hook the record companies in, and they're not. They're independent from Manson, and that can make the defense an interesting situation. And it's on the other side of the country, as Andrea said. So you can't be in two places at once. And I think the judge wants, for example, an in-person appearance for this Jane Doe hearing. So if they're going to be doing in-person things at this suit, you got to have local counsel, but your primary counsel and who's going to be where, and it gets very expensive. So firing up lawsuits on the other side of the country isn't, be better for Manson maybe if they were all in the same place. They all that one law. Now you have to figure out what the heck's going on in New York, plus all these things that happen that she says happen all around the country. And whether she has proof or not, well, we don't know any of that because there's certainly a lot of details that look really bad in the lawsuit. But whether they're provable and the things that are in between the lines, I didn't think it was any accident. I'm sure it isn't that they didn't mention Texas as a place where an assault occurred. You have to go online to figure that out. But with the anti-SLAPP and stuff that's available to the defendants, that stuff's going to come into issue, I think, fairly quickly once the defendants are served, right? I think we may have seen this lawsuit before Manson did. I don't know if his attorneys got an early copy or not. Maybe not. And so in that case, before he has to answer, they've got to get it to him and serve it on him. And that maybe it's happened by now, and maybe it hasn't.
I did want to ask, since she's using the New York Adult Survivors Act in this lawsuit, if you could explain or touch upon what this act is about, and I'll start with you, Andrea.
So this is an act that is similar to what we're seeing happening in California right now as well, where the state has basically expanded the statute of limitations for a limited period of time in order to be able to file civil claims that are based on prior acts of sexual abuse, sexual assault, things like that. So she is invoking this as a basis to revive claims that would otherwise have expired under the statute of limitations in New York, and very likely in the other states where they don't have these types of revival laws, hence why she is trying to bring all of them together in this umbrella under New York state law, because of the fact that these things happened so long ago that in most places those actions, she would have lost the ability to pursue them.
So Steve, you mentioned the several states and how that might apply. Why might Jane Doe be suing in New York and not any of these other states?
Yeah, so like Andrea was saying, this window they've opened in New York for assaults that occurred after you were 18, adult survivors, that's a 1-year window. Well, that's a good reason to sue there because you've got a new statute of limitations, and she says she was assaulted over the age of 18. But one of the things that made my head hurt was New York had previously opened a window for people who were under 18 when they were assaulted, and that window closed. And the new statute of limitations, while it's very long, it's not retroactive. So I'm a little unsure of what's really going to happen with her claim in terms of the things that happened when she was 16, because I don't think the new statute covers that. Maybe she's going to allege as a course of conduct and the real damages occurred when she was older. I'm not sure, but this has swept the nation in terms of these windows opening to go back and revive really old claims, and then also just changing the statute of limitations. When I looked at New York, I think they changed it to, if you're a minor who's assaulted now, you have until age 55 to file a lawsuit. I am an advocate of longer statute of limitations for sexual assault victims than had been in the past. However, 55 is a long time. I mean, in good faith, maybe you should have filed your lawsuit if you were underage before you wait until you're 55. In theory, the person who did it's older than that. So I don't know. There's no come down from heaven perfect amount of time for a statute of limitations, but it seems like maybe we've pinballed from this was maybe too tight to what in the world is going on with statute of limitations. They seem to change all the time. They're getting longer, and what state can outdo the other state? And Andrea had brought up a good point about the Texas statute of limitations probably had run. The New York one maybe hasn't. Whose law is going to apply? And then when I tried to look at that, I'm like, well, I'm not even sure the New York one's going to help her for her 16-year-old stuff. So I'm still a little confused on it. It's a lot of statutes and not a lot of case law on some of this stuff because it's new.
Yeah, I agree with that. It's one of the problems that I saw with her complaint that immediately struck me as like, this is potentially fatal here, is because we have to look at the specific claims that she's making. And so, for example, the sexual battery claim, count 1, she is relying specifically on these things that occurred in September and December 1995 when she was under the age of 18 years of age. Now, I understand they don't mention in the complaint where these things took place, which is quite a telling omission, getting back to that crafty drafting that I was mentioning before. But I understand it's pretty easy for folks to be able to go in and just look at the dates that are being alleged to identify where the concert was and know what law would apply and where the events were. And so my understanding is that these specific underage events took place in the states of Texas and Louisiana. And so I don't see a basis to be able to allege a sexual battery that took place in Texas or in Louisiana as a New York State cause of action, for sexual battery in New York State court. I think we might be looking at a different situation if we were looking at a federal court claim, or potentially as well if we were arguing something like, a conspiracy or like Steve suggested a course of conduct type of thing. I think they might get close to that with intentional infliction of emotional distress, because that could be, I suppose, based on a course of conduct. But by and large, those definitely seem to me to be problematic from a jurisdictional standpoint for these reasons that Steve is pointing out as well, that it doesn't seem to clearly fit within this, expanded and renewed statute of limitations.
And I know we didn't really talk about it too much, but kind of highlighted a little bit of the damning claims of assault of an underage minor, CP, even hidden messages in past records, posters, or lyrics. Is it likely we'll see these types of claims move forward? For example, is this something the anti-SLAPP can resolve, Steve?
Well, in my opinion, the anti-SLAPP does have a role to play there, right? It's for speech. And the New York revised anti-SLAPP statute is very broad. It's basically whatever isn't private. So I think that's going to cover that. And I think you're going to see that filed, and particularly by the record companies, because they didn't assault anybody. They're just alleged to have known about it and encouraged it with these things that they did. So I would be shocked if they don't file the motion. And of course, Manson probably will want to do it too. And it has a lot of the benefits that it had for Wood Gore, which is if they file this anti-SLAPP motion there, which I don't think they call it a motion to strike. I think they call it a good old motion to dismiss. It's old school. And if they file it, however, it does a lot of the same things, which is it freezes the other matters in the case. It freezes discovery. And they use the words in New York that it has to have a substantial basis to move forward with your claim. Maybe that's supposed to be a little more strict than California. I didn't see a lot of case law on it, but it's only been changed 2 years ago. So, it takes time to get appeal decisions to tell you what are the appellate courts going to say this means. When you read it, you think you know what it means. You need to see what they think it means, because they're the ones who get to decide. But I definitely think that stuff, while I understand the story that the plaintiff's trying to tell, which I think is a lot of that is, hey, these record companies knew about this and encouraged it and profited off of it. So they let him do what he wanted because he was making them money. I get what they're saying. But I mean, of course, that's kind of what is being said to the reverse in California, right? Hey, there was a conspiracy by Wood to knock Manson out, and the case has been stopped for a long time. And Manson people have been very frustrated. But this may be the reverse, where Manson's able to use this to his advantage in this state. I don't see why you wouldn't file it. And then once you do, we've all seen how that goes in California, until just how speedy the justice system works through these civil motions.
Yeah, Speedy.
Well, yeah, I mean, I think anti-SLAPP is inevitable in this case. And that's just because so much of this complaint is focusing on song lyrics, promotional materials, interviews, the, notorious autobiography, the Long Road Out of Hell. These are acts of artistic expression. They fall squarely within the First Amendment. And there's this attempt to conflate them in the complaint into, substantiating alleged acts that would be illegal, that would not be protected by the First Amendment. So, people have absolutely a right to make offensive art. I mean, there's a case about the Piss Christ, piece of art. If people don't know that, go ahead and look that one up. What's his name? Mapplethorpe, I think, is another one who got heavily criticized for, very graphically sexual depictions that was being funded by the National Endowment for the Arts. So these are not new issues. Like, this is well understood legal principles here. And I do not see a real viable way to take those out of that framework. So yeah, I think that the anti-SLAPP is absolutely going to be inevitable here. Again, without knowing the specific details of how New York statute works and what it would achieve, what the parameters and constraints and stuff are, I don't know if it would look like in California, where they literally just go out and strike out certain allegations in the complaint. I think if that did happen here, there would be an awful lot less that we would be reading here as a basis than what we currently have. But if it's a little bit of a different approach, where they just look at, can the causes of action stand if we remove these other allegations that deal with protected activity, would there still be a basis to go forward? That, I think, might be a little bit of a closer question. But yes, without question, the challenge is going to
I
happen.
was surprised to see the judge allow what looks like a challenge to Jane Doe's anonymity request. So I wanted to ask, is this typical? And I only ask this because I haven't seen this in any of the lawsuits yet.
Yeah, so I don't know if it's typical or not, but it doesn't strike me as particularly surprising. This order to show cause process is a fairly common way to deal with just certain types of questions and issues that come up in different types of cases. And so basically the idea is that yeah, he does have a right to contest it. He has a right to make an argument as to why anonymity isn't appropriate here. There's also considerations that deal with the public's interest in being able to be aware of who is participating in court proceedings, how the court proceedings are being handled, and that type of thing. So this is New York's way of doing it. Like I said, I don't know if that's necessarily normal, but it's a common practice for addressing certain types of preliminary questions like this.
Well, part of your question was they hadn't seen it before. And remember, in the Jane Doe case in California, when she filed that, I think she put a footnote in her complaint and said, hey, court, if you want me to file more materials to justify being anonymous, I will. And Manson did not concede that she was appropriately anonymous, but he didn't challenge it until they got into this confidentiality stuff. So he just kind of let it go for quite a while. But the court did say something about it. So like Andrea said, you can challenge it, as you should be able to make sure that the anonymous pleading is not being abused, right? That there is this justification, and there are certain things that if you can show that to the court's likely to let you be anonymous. But the defense gets to challenge that, and the defendant can try and be anonymous as well. So it can go both ways.
From your personal opinions as attorneys, what might we expect to see happen with this lawsuit moving forward? And I'll start with Andrea.
Yeah, well, I think the first thing we're going to see is, like Steve suggested, we're likely to see preliminary motions to dismiss, both, likely under the anti-SLAPP and potentially also under these jurisdictional types of grounds. Those things can typically be argued before the complaint has to be answered, because they go to basic, jurisdictional justiciability types of questions, like, are these things that can actually be litigated, in New York State court under this context. So I'm not specifically familiar with New York civil procedure, but that is, pretty commonly how these things unfold. So assuming New York handles their procedure the way everything else does, I think that's going to be the first thing that we see here.
Well, when you look at California and the anti-SLAPP, the defendants have been pretty good at bootstrapping some of their arguments that are not speech arguments to try and defeat Manson's claims. So, like, let's take the infamous FBI letter. They're like, well, it's not connected, or the comments aren't extreme and outrageous. So that's not really that it's speech or not. It's that your cause of action has a fatal element to it. The judge even said, well, I don't think she's pled in well enough to establish conspiracy and some other things like that. So that's a hint at how the judge may go on the anti-SLAPP. And maybe in New York as well, when they bring up the anti-SLAPP, they'll put in these things that Andrea's talked about in the motion to dismiss, to say you don't have a substantial basis for your claim because the statute of limitations is run and the jurisdiction is bad, and go ahead and put several grounds into a single motion to dismiss. I don't know their motions practice, but maybe you might see that.
I got an interesting question from one of the pro Manson accounts, and this was something I was wondering too. The question is, how can we handle the situation about naming her publicly, even though she spoke about her alleged abuse under her real name for 2 years and is now suing under the Jane Doe pseudonym, and they wanted a professional opinion? I'll start with you, Andrea.
Okay, well, I'm not going to give anybody legal advice about, what they can or can't say. What I will do is I will offer you how I personally will be guided by my understanding of this situation. So if it's anonymous, that basically is a protection for the people that are involved in this case. It applies to them. They're subject to the jurisdiction of the court. The rest of the public is not. Until you are noticed and brought within the court's jurisdiction for the court to be able to issue an order to you, you are not subject to a court order. So there is nothing illegal inherently, like per se, about using the, true name of the person who is being granted anonymity in this proceedings. That doesn't mean it's without risk, not just the types of, social consequences and stuff that Steve has mentioned, but also, things can be harassing, things can be threatening. There can be, other ways that the line can be crossed when it comes to that kind of speech. So personally, I don't intend to, bring it out. I'm aware that it's already out there for a lot of people. I don't think that there's anything wrong with that. There's, again, First Amendment activity protects the public's ability to comment on public proceedings. And to the extent there's already a substantial amount of public information out there that has enabled people to make the connections of, who and what we're talking about here, that's also within the public's right to do. So that's my personal take on the situation.
Steve, what's your opinion?
Well, everything Andrea said is correct. And you see it a lot in not just the Manson cases, but say like the gag orders in some of these criminal cases coming out of the Koberger case with the Idaho killings, or the Indiana killings, where there's gag orders and people like outraged that somebody across the country says something. But, orders aren't global, right? These courts have limited jurisdiction. That's why you have to the parties have to be within their jurisdiction. So remember that when you see people talking about things and you're mad because you wish they weren't talking about it, they may not be bound by the order. And having said that, my position will be, well, if she's anonymous in the pleading, that's how I'm going to leave it. Although I don't think I'm bound by the order, but I'm just not going to say it because that's how they've set the order up. Now, if the secret police come to get you and take you to Gitmo, don't say that the guy on the internet said they're not global orders, bro. Because like Andrew said, everybody, you do what you want, be yourself.
I don't think a lot of people will get that Gitmo reference, though.
That's too old school too.
I think it's too military. What do you think about the antics of Jane Doe's law firm on social media, posting all this stuff the way they are and everything, and seems to be promoting themselves in that kind of way, whatever. I'll start with you, Andrea.
Yeah, so I have not seen everything by any means. I'm aware that there is a lot, and probably a lot more than I have seen that's out there. The limited stuff that I have seen strikes me as enormously tasteless. Okay, it's just like the grossest kind of ambulance chasing, and it's also it seems to me to be a little bit of an own goal in some respects, in the context of an overall dispute that involves concerns about, alternative motivations, financially based motivations for bringing these kinds of claims, as well as collusion, attempts to hunt down and put forward, different people who will make similar types of accusations. This type of approach is often problematic because there are a lot of not well people out there who, can be easily led, who can, imagine something that did not actually happen, but for various reasons, this person might be very suggestible. They might have, other mental health issues going on. So it's risky to do that kind of thing because you're going to get a lot of crazies, probably more crazies than you're going to get legitimate complaints. So it's extremely tasteless what I have seen. Attorneys are subject to professional rules of conduct, and most of those professional rules of conduct have specific rules about trial publicity. And usually that will include things like you are not allowed to make public statements that basically create a substantial risk of impairing somebody's right to a fair trial. And so that can include things like opinions on guilt, opinions on, I should say, like bringing out evidence that may not be admissible, things like that. These rules tend to be a lot more strictly enforced in the context of criminal trials, not civil trials. But this is a situation where there's kind of an overlap between, it's a civil case, but there's allegations of criminal activity and stuff like that, that are, being leaned on and reflected in some of the advertising materials that I've seen. So it's potentially something, it's a fine line from my perspective that they may be walking from an ethical standpoint. That said, are they likely to suffer any real consequence from it? I doubt it. I mean, attorney advertising is what it is. That ship has sailed, and it's just an unfortunate part of the degradation of the profession that a lot of us have to deal with today.
Steve, what do you think?
Well, I haven't seen him put out in front of their office yet one of those things that has the air blower and it waves around like that. So maybe that's still coming. But I had in my note here about your question. You want to make hay while the sun shines, and I know they're doing, I think, a live stream or something this afternoon. And so, okay, so is there an element of raising victim awareness because normal people don't monitor statutes of limitation changes for real victims? Yes. On the other hand, when I was researching this and looking at the child window that occurred in New York that was, I think, 2 years long, there were over 10,000 lawsuits filed in New York for those kind of suits in that period in New York. That's just one state. So, whether it helps or hurts you, maybe on Manson's situation, if you get this kind of publicity, it might bring people to you of merit or not of merit, but it's a lot of lawsuits. And we had, a window in North Carolina for child sexual abuse victims, and it closed. And that December, the plaintiffs' firms were filing lawsuits against anybody they could find, even if they knew they might drop them later because they had the wrong defendants and things, because that window was closing. I don't know how many suits were filed just in this state. I had to defend one under that window for somebody that was frivolous. So I know at least one frivolous lawsuit occurred, and probably a lot more. Not saying they're all frivolous. My point is, it's a lot of lawsuits with distant memories, short time frames sometimes to get these things filed. So I imagine since they're doing these cases, you want more of the same kind of cases, right? You got your experts lined up, you know how to file the pleadings and things like that. If you have 5 sexual assault cases, 100 would be better, right? So it's advertising in that way, to me, more than maybe it raises victim awareness. If it gets engagement, who knows these days, social media, whether anybody's looking at it or not, but we saw it.
Yeah, I can't wait to watch it if I can stay up for it. And that was my last question, but I wasn't sure if you guys had anything else you wanted to add that I could plop into the video or podcast to end this. Andrea?
Yeah, well, one of the questions that I got that I've also seen recur is the fact that these underage forcible sexual assault allegations are serious criminal allegations. Are these things that could be potentially pursued in Texas and in Louisiana where they, allegedly occurred? And the answer to that is yes. Texas has no statute of limitations for allegations of sexual assault against a minor, specifically, called out in their statute as something that there's no limitation period at all on their ability to charge that. Louisiana has a statute of limitations for different types of sexual assaults, including sexual assaults on minors, that is 30 years from the date that the alleged victim turns 18 years old. So both of those allegations, as I see, are going to be still within the criminal statute of limitations in those states. And so that suggests very strongly to me that were there any merit to them, had they been presented to those authorities, they would be pursued. There's no legal cause why they couldn't be.
Oh, that's a good point. Steve, did you have anything else?
Well, one thing is we did mention, the plaintiff's attorneys have made it clear not only through the language in their complaint, which is the traditional way of getting your point out without worrying about getting sued for defamation or whatever. They're also talking about it a lot. But Howard King, I think, has also issued a statement where he's denying on Manson's behalf the factual basis for the complaint, saying that this just didn't happen. So I do want to get that point out there, too, that, the battle is joined here not merely on technicalities and statute of limitations and that sort of thing, which, if he did it, it's fair enough to use those tools, but those are technical tools. He is saying this didn't happen. And, I wish all the legal stuff didn't swirl around it, because, if you're watching it and in these kind of cases, you want to know, did he do it or not? And if he didn't, he shouldn't be punished and dragged through all the mud stuff. And if he did it, he should. So, he's been very clear on this, is what I want to say about the King situation. It's not like, say, with Woodard, where they had a consensual relationship, and you could imagine, that with the drugs and everything like that, that maybe, you could imagine different perceptions of some of the things that occurred between them. In this case, if he did things with her underage, that's going to look bad. And he is saying that did not happen. So I do want to point out that there's a clear factual divide there between the parties.